Welcome to the Topic 1 lecture in LWZ 304 Administrative Law. This is Introduction to Administrative Law, and you've just heard on the title slide an extract from Lou Reed's Perfect Day. Of course, every day that you study administrative law is a perfect day. That's what I think anyway. Now on this slide we see the reading for this week's lecture. The prescribed reading is chapters 1, 2 and 5 of your prescribed text by Crike and Macmillan, and or chapters 1, 2, 3 and 4 of the shorter textbook by Michael Head. There's also additional reading there, an article by Crike. Now before we start to look at some administrative law theories, we will just focus on a seminar question that we're going to be looking at in the week 1 seminar. This is the approach we're going to be adopting this semester. You'll be listening to these recordings. They'll highlight seminar questions, and then we'll be looking at those and discussing them in the seminar, first in breakout rooms and then as a group together in the Collaborate room. And the first seminar question is a relatively general one. It is said that administrative law is a body of rules that regulate the interaction between the state and the individual. How does administrative law differ from other interactions the state and the individual may have? Now, other sorts of interactions one may have is if you have interactions with the police, for instance, over alleged speeding or drunk driving or illegal parking or something like that. Others may be if you've entered into a contract with the government to provide it services, or the government has entered into a contract with you to provide services. You'll have interactions with the government, legal interactions with the government, but they're not administrative law interactions. Similarly, if you believe the government has been negligent or something, you've been injured by some failure by the government in relation, for instance, to how it designed and maintained the roads or a set of traffic lights or something, and you've been injured as a result, or they haven't properly maintained the local football oval and you've fallen over and broken your ankle or something, you might sue the government for negligence. Those are among the many ways in which you might interact with government, but they're not administrative law. How do they differ from administrative law as a body of rules regulating interactions between the state and the individual? What we're going to cover first in this lecture recording is some administrative law theories. So we're setting the scene here with themes and theories that I want you to be carrying in your head for the next 12 weeks as we study the particular topics in administrative law. Well, what are those administrative theories? Well, this slide lists them for you, and we're then going to go through them one by one. We're going to look at something called green light versus red light theorists. We're going to ask ourselves the question, can we look at administrative law as a partnership between the courts and the government in effective, efficient and fair running of a relationship between government and the community? There are some tensions in looking at it that way. You'll have probably thought already, because of the separation of powers, and the courts and the political arms of government are not the same thing. Administrative law versus managerialism is a really interesting topic that I'll be spending some time on, both in this half of the lecture recording and in the second half that you'll be listening to later. And so it goes on. Each of those dot points I'll be spending a little bit of time on. The other thing, though, hopefully you've read the introductory blurb there before those dot points about the relationship between government and community being complex and multifaceted, and therefore we need to look at all these theories to some extent and have a think about them to try to make sense of the large range of administrative law mechanisms that are designed to try to govern how governmental power should be controlled. And that includes, of course, the Ombudsman, freedom of information legislation, anti-corruption commissions, merits review tribunals like the Administrative Appeals Tribunal and VCAT and NTCAT and so on, and of course judicial review of decisions of ministers, departments, agencies, public servants and so on. All of those things we need to look at in an overview sense as well as in detail. You know, we don't want to get lost in the forest and not see the wood for the trees, so to speak. And that's what this lecture is designed to do, for us to look at administrative law theories and concepts and themes in an overarching sense. But before I go on to those individual things, I'd like to read out a little bit from Aronson and Dyer's administrative law textbook, which I think is a really neat place to start about what is administrative law, which of course we touched on in the quick tour that you've already listened to. But Aronson and Dyer have this to say: defining administrative law is a topic on which few commentators can reach agreement, because it ultimately depends on what they want out of administrative law. We know what we want. As a minimum, we want a legal system which addresses the ideals of good government according to law. We take those ideals to include openness, fairness, participation, accountability, consistency, rationality, accessibility of judicial and non-judicial grievance procedures, legality, and impartiality. Well, that's a pretty big wish list, isn't it? But every one of them I would have thought is fair enough, and I certainly expect all of those things, but like Aronson and Dyer, I'm sometimes disappointed. Australia's administrative law system doesn't always live up to those ideals in practice. But equally, I think I'm an optimist. I think Australia's system overall is pretty damn good. Better than most Western liberal democracies, certainly in my view, better than the United States, at least as it's functioning at the moment. So I don't think we need to apologise for our system of government and the practical freedoms and fairnesses that it does deliver. Now, the first of the dichotomies that we want to focus on is what could be referred to as judicial regulation versus legislative or executive autonomy. What is the proper role for the courts in overseeing legislative and executive autonomy? And again, this interacts with the separation of powers doctrine. Marbury and Madison and so on, that the legislature makes the laws, the executive enforces or administers the laws, and the judiciary interprets and adjudicates disputes about the law. Now, each one of those three arms, functional arms of government, are co-equal. So what is the proper role of courts? They're certainly not the boss of the political, legislative or executive, because of course the politicians are elected by the people. And we certainly wouldn't want rule by unelected judges, and that's what we sometimes get complaints about, so-called judicial activism. And that's touched on by your Crike and Macmillan textbook, where they have this to say: Parliament, government agencies and courts and tribunals all have a role to play in government administration. Inevitably, lines must be drawn about which matters properly fall within the responsibility of each actor in the government system. Not only will those lines be blurred, but there will be differing views on where a line should be drawn. In a public law context, the debate is often cast as a clash of values or styles between judicial activism or overreach as against executive antagonism to proper judicial scrutiny. Now, the so-called Mason High Court, under the Chief Justiceship of Sir Anthony Mason in the late 80s, early 90s, was often accused of being excessively activist. That's when we got the Mabo decision and the implied rights and freedoms decisions and a range of other quite revolutionary changes in Australian law. More recently, Justice Michael Kirby has also been frequently accused of being a judicial activist or a judicial legislator, exceeding the proper role of a judge, if you will. But is that right? What is the proper role of the courts versus the political arms of government? Well, that's something we will certainly be looking at, a theme we'll be returning to through this semester. Regulation. Now, the first of the dichotomies that we want to focus on is what could be referred to as judicial regulation versus legislative or executive autonomy. What is the proper role for the courts in overseeing legislative and executive autonomy? And again, this interacts with the separation of powers doctrine. Marbury and Madison and so on, that the legislature makes the laws, the executive enforces or administers the laws, and the judiciary interprets and adjudicates disputes about the law. Now, each one of those three functional arms of government, are co-equal. So what is the proper role of courts? They're certainly not the boss of the political, legislative or executive, because of course the politicians are elected by the people. So we certainly wouldn't want rule by unelected judges, and that's what we sometimes get complaints about, so-called judicial activism. And that's touched on by your Crike and Macmillan textbook, where they have this to say: Parliament, government agencies and courts and tribunals all have a role to play in government administration. Inevitably, lines must be drawn about which matters properly fall within the responsibility of each actor in the government system. Not only will those lines be blurred, but there will be differing views on where a line should be drawn. In a public law context, the debate is often cast as a clash of values or styles between judicial activism or overreach as against executive antagonism to proper judicial scrutiny. Now, the so-called Mason High Court, under the Chief Justiceship of Sir Anthony Mason in the late 80s, early 90s, was often accused of being excessively activist. That's when we got the Mabo decision and the implied rights and freedoms decisions and a range of other quite revolutionary changes in Australian law. More recently, Justice Michael Kirby has also been frequently accused of being a judicial activist or a judicial legislator, exceeding the proper role of a judge, if you will. But is that right? What is the proper role of the courts versus the political arms of government? Well, that's something we will certainly be looking at, a theme we'll be returning to through this semester. Regulation by the judiciary, as opposed to the autonomy of the political arms of government, the legislature and the executive, is a recurrent theme in this unit, because there's a tension between those bodies and who one thinks ought to have primacy. Parliament, government agencies and courts and tribunals all have a role to play in government administration, and inevitably lines must be drawn about which matters properly fall within the responsibility of each actor in the government system because of our separation of powers doctrine. Not only will those lines be blurred, but there will be differing views on where the line should be drawn. In a public law context, the debate is often cast as a clash of values or styles between judicial activism or overreach as against executive antagonism to judicial scrutiny. And those who, including judges, who disfavour what they see as judicial activism, often adopt an approach labelled formalism or legalism. Now, the Mason Court, the Mason High Court under Chief Justice Sir Anthony Mason, was often characterised as activist or adventurist, composed of judicial legislators, rather than sticking to the traditional limited role of courts on appeal and judicial review. Similarly, of course, Justice Michael Kirby was also repeatedly labelled as a judicial activist, if you will. So that sort of issue, to what extent should the courts, and the High Court especially, adopt a role that some might see as activist, to what extent should they stay in their little box, if you will, is a theme that will come up recurrently through this course. Red light and green light theorists is the next dichotomy that's highlighted by Crike and Macmillan. It was a term or a dichotomy first adopted by British theorists Harlow and Rawlings, and their theories described as follows by another author. Administrative lawyers were divided into red, green or amber light theorists. Red light theorists sought to stop the collectivist state from redistributing wealth and interfering with personal liberty and private property, and focused on controlling, in the sense of restraining, state power. At the other pole are the green lighters, who sought to use the law to facilitate the state to regulate, redistribute and provide services. In between, as on a traffic light, are those under the amber light. These theorists conceded the desirability and need for the exercise of public power, and thus reject the view that public power should be seen exclusively in terms of control of such power, but would argue that reliance on traditional political techniques for promoting accountability and control is inadequate, and forms of political control need to be buttressed by legal control, including obviously things like administrative law, avenues of accountability, the Ombudsman, freedom of information, administrative tribunals like the AAT, and so on. Now, before we go on to our next little dichotomy, this slide mentions a seminar question that we will be addressing in our very first seminar in week 1 of the semester. And it focuses on this strange red light, green light analogy or metaphor. The question, which we'll be discussing initially in breakout rooms and then together in the second part of the seminar, is this: what is the difference between red light and green light theoretical approaches to administrative law? Well, I've just gone over them, haven't I? Explain your answer by reference to a recent government policy announcement. This is where you'll have to do a little bit of thinking and figuring. For instance, the recent recommendations of the Banking Royal Commission handed down by former High Court Justice Ken Hayne. Now, you can look at those recommendations, which you'll find summarised all over the place in the media, in terms of whether they exemplify a red light approach or a green light approach or an amber approach to the regulation of the activities of actors in our political and economic system, in this case banks and insurance companies and so on. So we'll be discussing that during the seminar. Joy that you've got in store. Now this next dichotomy, individualism, I've slightly misspelled it, and collectivism, is in some ways a different way of expressing the red light, green light thing that we just spoke about, but there's a little bit more to be said. An explanation given in that Harlow and Rawlings quote as to why some administrative lawyers prefer restraint while others favour legal intervention has to do with a preference for an individualist or a collectivist view of the state. Or you might say a classical liberal view versus a socialist or social democratic view, if you want to put it in terms of politics and political science. The collectivist view is premised on the belief that decisions have to be made within a framework of policy that recognises broader social concerns, such as the rational allocation of limited resources and the need for consistency and predictability in government administration. That perspective is generally taken by the legislature and the executive, which are concerned with ensuring both distributive justice and horizontal equity, consistency, fairness and so on. This view supports the need for judicial understanding or deference to the different role of the executive, and for that matter, a degree of deference perhaps on the part of administrative tribunals like the AAT and VCAT and NTCAT and so on, given that they undertake independent merits review. To what extent should they favour the collectivist approach of consistency and fairness and distributive justice, as opposed to maximising individual freedom of individual citizens who are challenging a particular decision? The contrasting approach is that administrative review is properly concerned only with ensuring that individual justice is achieved in resolving the individual dispute or claim before the adjudicative body. So again, this is a theme that will be coming up time and time again that you should keep at the back of your mind as we go through our studies of administrative law this semester. The next dichotomy, rule-based versus substantive justice, is again another way of looking at something that I've already talked about. The contest, if you will, between what's sometimes referred to as judicial activism on the one hand and legal formalism on the other hand. An ordered society requires people to comply with defined rules, A just society may look more searchingly at whether the rules comply with accepted universal norms of fairness and equity. Should administrative law pursue formal legality or administrative justice? Should form or substance triumph? A positivist view, in jurisprudential sense, is that rules gain validity and authority through their process of creation and the sanctions that can be used to enforce them. The content of rules is important, but must generally be accepted once made. So legal formalism triumphs, I guess, on that view. Even if we don't like them and think that they're not necessarily all that fair, we just have to suck it up and obey them. A contrasting view is that rules acquire meaning partly through the way they're interpreted and applied. In those processes, there is considerable scope to examine whether rules align with human rights norms and accepted moral principles and fundamental freedoms. Nor are all review bodies expected to take merely a formalist rule compliance approach. A particular function of the Ombudsman, for instance, and similar bodies, and to a limited extent administrative tribunals like the AAT and VCAT and NTCAT, is to comment upon whether a substantive outcome is fair or defensible. So again, that's a theme that we'll be looking at through the semester. Now we come to another seminar question that we'll be addressing at least to some extent during the week 1 seminar. And this question is it best practice for Parliament and the Executive to prescribe detailed regulations and stipulations in policy documents which bind government decision makers and give certainty to the public? Or alternatively, should decision makers be given discretion, guided by legislative and policy objectives? Identify the benefits and drawbacks to each of those approaches. So again, you need to have a think about that before you come along to the week 1 seminar, and we'll discuss it first in breakout rooms and then together in the main room. Just a couple of examples of where that sort of prescriptive approach has been adopted. The Migration Act these days and the Income Tax Assessment Act have both been quite deliberately made more and more and more detailed over the years, more and more prescriptive, more and more tick-a-box approach in order to reduce the capacity for aggrieved citizens to go and argue before the courts or the administrative tribunals that their case is exceptional and that a discretion should be exercised by the independent tribunal or whatever, because the government in those particular sensitive areas, revenue and migration, especially with refugees and so on, is determined to make sure that its will prevail and not that of the courts or the tribunals. And so the view's been taken that the best way of achieving that is to make the rules detailed and prescriptive. So you either comply with them or you don't. There's no room for discretion. If you don't meet every criterion, you don't succeed. Is that the best approach, or is it better to have a discretion so that the result can be tailored to individual justice? Interesting question that we'll be discussing. Now we come to Now the next dichotomy is one that I'll also be returning to in part B of this introductory lecture, and that's contracting out and managerialism versus traditional public sector management. Now, many of you will know, if you've been around and following these things for a few years, that over the last 15 or 20 years, really, there's been an increasing trend to contracting out traditional public sector functions to the private sector. So, for instance, the job network is a classic example. Finding jobs for the unemployed used to be a task for the public service. Now it's been contracted out to private job network providers. Whether that's improved things or not is a matter for debate, but certainly increasingly that's been the case. Increasingly many previously public functions are now undertaken by private bodies. In many states, for instance, the provision of electricity and power and water has been privatised. At federal level, Qantas used to be a public utility. Now, of course, it's completely private. And so it goes on. At state level too, many bodies have been privatised. For instance, the Darwin port is now privatised and run by a Chinese company called Landbridge. Now, to what extent all that's a good idea is debatable, and we'll be debating it during the seminar. The next thing is managerialism, and this is that even where functions continue to be performed by the public sector, increasingly, starting in the 1980s but continuing till today, there's been a private sector managerialist approach taken to the way you run the public service and the way things are managed and controlled, the way accountability is supposedly ensured. The managerialist philosophy results in outputs and economic rationality becoming the standard for measuring success. That shift reflected dissatisfaction with bureaucracy back in the 70s and 80s for its slowness, inefficiency and profligacy. A key managerialist tool was the efficiency dividend, achieving more with less by annually shaving a set percentage off last year's budget of each agency. The managerialist philosophy didn't disregard the need to comply with legal rules, but could be impatient with the way that administrative law compliance could slow processes down, attribute undue weight to formality and procedural fairness, and enable disgruntled individuals to control the agenda. The managerialist philosophy, at least so Crike and Macmillan assert, is no longer advocated in the same terms as it was in the 1980s. I can't say I've noticed the difference. But it caused an important shift in public administration in Australia and led to many other changes that affected administrative law, such as contracting out and the statutory control upon ministers of powers to give directions to officials. It also resulted, I might say, in the creation of something called the Senior Executive Service, both at Commonwealth level and in the states and territories. And that meant and still means that heads of department and indeed the second and third tier of senior executives are basically political creatures. They're subject to short-term contracts. They can be hired and they are hired and fired by the political government of the day. They don't have traditional public service permanency, and therefore they're much more responsive to the will of the government of the day. Now, that has its good aspects and its bad aspects, and again, we'll be discussing that in the Week 1 seminar. Now, it looks like I've got my slides slightly out of order here, but rather than reordering them and disrupt the recording of this presentation, I'll just commentate on them out of order. This is supposed to be the last slide, and it says, "But wait, there's more." Those of you who are nearly as old as I am will remember that was a slogan by a company called Demtel, who sold lots of things mostly by TV ads, and their favourite slogan was, "But wait, there's more. If you ring in the next 5 minutes, you not only get the dicer, slicer, and carving knife, but you also get the blender, and you get the chopper, and you get all sorts of other things as well." So in this case, that's what I'm referring to. We now go on to part B of lecture presentation 1, Introduction to Administrative Law, where we look at some more theoretical or conceptual aspects of administrative law. What does it all mean, I say? Well, we'll see in the second part of the lecture, but before we get to that, I'm just going to focus very quickly on another seminar question that we're going to be discussing, and it was implied in my discussion a minute ago about managerialism. As I say, we're now going on to part B of the introductory lecture, but before we do, here's the third of the seminar questions that we'll address to one extent or another. I mean, we might well run out of time and not get through all of them, but it's the aspiration anyway. And the question that I want you to be considering and having a think about, making some notes about before the week 1 seminar, is what are the pros and cons involved in importing new managerialist management techniques into the public sector? Might there be a difference between public servants who are part of a profession, for instance doctors or scientists or accountants or economists or lawyers on the one hand, and ordinary line administrators who are just responsible for processing applications, inquiries and so on from the public? You can argue, I think, that those latter sorts of frontline public servants, it may well be appropriate to adopt to a significant extent managerialist approaches to make sure that they deal with things promptly and efficiently and all those sorts of things. But once you get to more thoughtful professional functions within the public service, perhaps managerialism needs to have less emphasis. There needs to be perhaps a more thoughtful, flexible approach to ensure the best quality of service to the public. In any event, that's the end of part A of lecture 1. We go on and you can listen to part B, a separate recording at your leisure, but certainly before the first Monday of the teaching semester.